Hi everyone. So we now have a letter that has been filed on the docket by Jed Wallace. He's filed leave to request to respond to Blake Lively's opposition to his motion for continued sealing. Okay, so dear Judge Liman, non-parties, Jed Wallace and Street Relations move for leave to submit the following reply to Blake Lively's letter response to the Wallace non-parties not letter motion for continued limited sealing. Good cause exists for this request for leave. Though previously ordered to produce highly confidential and sensitive information while they were parties, Wallace and Street have been dismissed for want of jurisdiction and are no longer parties to this litigation. Further, the proposed limited redactions of the confidential and business-sensitive documents the Wallace non-parties were previously ordered to produce involve the privacy rights of third parties and Street's own non-public and sensitive business information. In other words, the circumstances before the court involve non-parties, the Wallace non-parties, seeking to protect their own and other third-party privacy rights for information that bears no relation to Wayfarer, Lively, or the issues in this litigation. Non-party identifying information. The Wallace non-parties move to continue sealing both references to non-party individuals and information through which the individual's identity could be revealed, such as the individual's gender, locations, industry segment, and timing of their inquiry into Wallace's services. Lively's own sealing request acknowledges that non-party privacy interests are a legitimate countervailing factor to be considered against the public's right of access. And Lively recognizes that identification of third parties may increase the risk of exposure to harassment in the press and/or social media, and poses security, safety, and privacy risks, which is a higher value that warrants continued sealing. Rather than acknowledge the similarities between the non-party information the Wallace non-parties seek to maintain under seal and that which Lively herself seeks to maintain under seal, Lively claims that gender, location, industry segment, etc., do not provide the public a map to identify the underlying client. That wishful view ignores the realities of who confidentiality seeks public relations and crisis mitigation services, and when and why. If roles were reversed and the prospective client for public relations and crisis mitigation services was an actress in New York in August 2024, there can be no doubt that the public could identify the prospective client as Lively using a basic Google search. Gender, industry segment, location, or timing of a public relations inquiry can be enough to reveal the identity of third-party prospective clients. Given the intense public scrutiny surrounding this case, the disclosure risk to third parties is heightened here. This court has already held that information revealing the specific identity of clients and prospective clients who have used public relations services is sufficiently sensitive to warrant continued sealing. Because these persons did not ask to be involved in this lawsuit and their privacy interests as third parties should weigh heavily in the court's balancing equation, information that could be used to identify non-party clients and prospective clients should continue to be sealed. Non-party, non-disclosed commercial information. The Wallace non-parties also moved to continue to seal their confidential and proprietary bespoke pricing information. Lively recognizes that confidential commercial information is likewise sufficiently sensitive to shield from public disclosure, as she explained to the court in seeking to seal non-party commission rates. So too here. The Wallace non-party's pricing information is confidential commercial information akin to the non-party commission rates that Lively argues should be sealed. The need for sealing is even greater here, where both the service provider and the prospective client are non-parties, unlike plaintiff's Lively's commission rates with WME. Lively claims that more is needed to show what competitive harm the Wallace non-parties would endure if their non-disclosed commercial information were revealed. But her own request for continued sealing makes the same kind of statement about competitive harm that she now alleges is conclusory and insufficient. And Lively's cited case is an opposite. There, the court found that there was, in fact, no secret about the defendant's pricing and general business practices, and nothing that was even arguably confidential. That is not the case for the Wallace non-party's bespoke pricing for non-party prospective clients, which is sensitive, non-public information that could cause the Wallace non-party's competitive harm if disclosed. Courts in this district routinely permit parties to seal or redact commercially sensitive information in order to protect confidential business and financial information. The Wallace non-parties ask that the court do so here by continuing to seal their non-party, non-disclosed commercial information, reflecting pricing offered to non-party prospective clients. References in deposition testimony. Last, Lively challenges the Wallace non-party's motion to seal certain confidential information contained in Wallace's deposition. Let's see here, is there a footnote? Oh, the footnote is completely redacted. Lively cites no authority for unsealing information related to payment of Wallace's legal fees. Unfortunately, we already know that from Sarowitz's deposition. And it is irrelevant that no other party has sought to seal this information, which is personal and private to Wallace. This is private, non-disclosed information about a non-party's financial affairs that should weigh heavily in a court's balancing equation when considering the presumption of public access. I am going to disagree with that. It is not non-disclosed. It has been disclosed, but yes, not by Wallace himself. I appreciate that. I'm not sure how the court would deal with that, but it is public information. So I think that will weaken Wallace's argument here. It's definitely something I know about. I know that Sarowitz is paying the legal fees of all Wayfarer parties, all the defendants, including Jen Abel, Tag, Melissa Nathan, and he is also paying for Wallace and Street's legal fees too. That's knowledge. Okay, we continue. Because there is no dispute about the private nature of this information, nor that Wallace has kept this information confidential, the Wallace non-parties ask the court to continue to seal this information within Wallace's deposition. Okay, so he's looking to get it sealed in his own deposition, but all I can say is that it has already been disclosed in Sarowitz's deposition, so I wouldn't be surprised if that part didn't get sealed. The rest of it, he's made great points, so I do love it when Wallace's counsel come and, basically bitch slap Lively. Remind her what a hypocrite she is. While we're here, we also have... sorry, let me just... No, now I can read it. We have an order from Judge Liman on the hearing, which is scheduled for January the 22nd. It's in person, so there's not going to be any dial-in or anything. I think Lauren was planning to go. I don't know if that's still the case. I think it is, but I know she was certainly intending to go. We've also got Matthew from is it Docket Updates on X? Yeah, okay. So the parties have sought guidance from the court regarding the scope of oral argument, which is scheduled for January 22nd, 2026 at 9:30 a.m. And it's going to be in the court. As indicated in the court's order of December 9th, 2025, the court will hear argument on the Wayfarer parties' motion for judgment on the pleadings and motion for summary judgment as to Lively's claims, as well as Lively's motion for the spoliation sanctions. The court will allocate 2 hours for argument with 1 hour per side, As the moving parties on the motion for summary judgment and motion for judgment on the pleadings, the wayfarer parties will present first and may reserve time for a rebuttal. So basically, wayfarer get to present their case first. The lively then, I'm not sure how this is going to work, like, because it's an hour each, out 2 hours per side. But Jones Works is also involved in that summary judgment, so I'm not quite sure how much time she's been allocated. Because obviously you've got Jen Abel's conditional summary, yes, motion for conditional summary judgment. I'm not quite sure how that's going to work, but okay. So yeah, wayfarer will present their argument first, then lively will come in and present her argument. Wayfarer said, he's saying, wayfarer, you need to like, they get to come back again and kind of, clean up any points after lively has submitted her side, and that's called a rebuttal. So wayfarer are to reserve some of their time, their hour allocation, for the rebuttal. The parties should be prepared to address the arguments in their papers that they believe present the strongest basis for granting or denying the motions. There we go. All right. I will, yeah, so that's that. We'll see. I don't know if Lively will respond to Jed Wallace or not, or if Liman will just rule as it is now. But we'll see how that goes.